I pardon to mention two inter-court appeal. One is 2023, another 2024 phase regarding pension and rehabilitation. So you also may put in next week. No, one is pension matter. The deceased husband was working as a junior engineer. After expert, the family pension has not been paid.
Both the same matter?
No, both. Another is rehabilitation, direction for reputation disposal. Now the government has filed appeal.
Well, the pension matter next week. The other matter, week after next.
Well, this is regarding a writ appeal we had preferred. It was supposed to be tagged with another writ appeal filed by the... It was listed on 18th. It did not come up. This might be listed again.
It will come. What's this matter? 2025 writ appeal?
2023.
This 25 is to the past court.
Now, regarding another writ petition for admission, here the petitioner retired as a district judge in selection grade. 25th.
25th of August.
July.
July, very. It is very near.
First week of August.
Second week of August.
Grateful.
I want to mention one matter one matter I filed an IA for recall of order returns also.
Calling the order?
Yes,
next week.
For orders. I may further to make a mention. Item 31 of the list.
31.
You go page by better. Sorry.
Page 11 to 15. Page 4, 16 to 20.
Item number 18.
18 what time? 24 matter. All right. First week of September.
Oh, bless you.
What the other side?
I have taken consent of the other side, Your Lordship. Serial number 18.
Orders matter, usually they are not adjourned. Orders matter, usually it's not adjourned, so we do not know what purpose it has been listed. I mean, the tradition is the orders matter should be taken up, then it can be adjourned, but not at the beginning.
That's the procedure in our court also.
Almost everywhere.
This has been mentioned.
They mentioned that not to be mentioned.
You have informed the other side.
I have taken consent.
Okay. No reason to disbelieve.
Page 5, 21 to 25.
My lord, item number 23, my lord.
23.
In this case, I am appearing to the respondent, my lord. 2 days back, I have entered my appearance, my lord, pursuant to the notice of your lordship, my
You
lord.
have informed Mr. Bose?
My lord, I will inform, my lord. Just now.
Not in future. No, that's not the way to do after the defense.
Yes.
Then wait.
Yes,
Let him come. Then
yes,
wait.
One way is that if you are not there, then inform many of
Yes,
your
yes.
friends.
Yes.
Page 6, 26 to 30.
My lord, item number 30 can be taken up on 4th of August.
You are for the?
And for the petitioner.
Appellate.
Yes.
Well, in this case, I'm appearing for the respondent lordship. In this case, lordship can
Not objecting for you can. But
Recording stopped.
7, my lord, it's a intra-court appeal filed by the state, wherein there was a delay and delay has been last occasion, it was condoned, my lord, 185 days. And my learned friend who is appearing for the sole respondent, they have also entered appearance through caveat.
Yes.
On the last occasion.
Not last.
In the matter, make a statement.
This is a matter regarding appointment of Swechhasevi Shiksha Sahayak.
Shiksha Sahayak.
Yes. Which was originally, it was not a non-education facilitator, subsequently Shiksha Sahayak. Then the person who are continuing for 6 years, they will be appointed as a junior teacher. So the question of advertisement comes, as per the letter they have been appointed, subsequently when the advertisement comes, then there is the crux of the point by virtue of that advertisement in a particular district of Kendrapada. These are the limited posts which has been advertised. Against this respondent, petitioner in the writ application was appointed.
Appointed as a
Swechhasevi Shiksha Sahayak, SSS.
Swechhasevi volunteer. Swechhasevi. Okay. Voluntary
Swechhasevi Shiksha Sahayak.
Shikshan. Shiksha Sahayak.
Education volunteer.
Okay.
They call them education volunteer.
Education volunteers.
Okay.
In the primary education,
That order refers to 2 writ petitions.
Yes.
Orders into writ petitions.
other successive 2 writ applications.
Where are they? In the brief, anywhere, or please open page 27. Column. Writ application, page 27.
What were those 2 writ petitions about?
One is 19120.
Numbers is different. No.
11748.
11748. Can you look at Annexer 7? You have the writ petition, or you look at the paper list. Mr. Mahanti.
No, no.
Annexer
I
7.
provided to you, na? Your colleagues should open that actually. That way,
Annexer 7.
like I am opening in
12813.
Yes.
that is dated 27/10/18.
Yes.
Got that? It's 27/10/18.
They have been designated.
District Project Office, Sarva Shiksha Abhijan, Kendrapada.
Kendra.
So kindly mark those 2, the second line, third line. Mr. Rathore, you are having copies?
In petition,
Order. At least order. Order. Or can you search in the court website? Whatever.
12278.
Page 27. Why you are reading, sir? Why you are getting these numbers?
Order 12278 of 2006. Order is a pilot file. See the flag F, the note I have filed of page 41.
11748 of 2003.
Yes, ma'am. Page 27. In
That-
case the
that-
petitioner and in the event of the opposite part number 3
No. 27 of what you are reading, sir?
of the writ application.
Annexer 7. It doesn't match. You are reading something else. Or maybe I am holding a wrong brief. This is a writ appeal
1825.
1825.
arising out of WPC 19120 of 2018.
Yes, ma'am.
So that is scanned copy reflects that only.
The disengagement order is questioned.
First.
That you are challenging.
Yes.
What is the fault with that order?
My humble submission contention of this article, the earlier appointment which was made not in pursuance to the advertisement, rather it is by virtue of one letter he has been appointed.
That was when?
That was Advertisement was 25/3/2023.
Huh? 23. How can that be?
2003, ma'am. 2003, sorry. Advertisement at 25/3/2003.
Huh. And the candidate was appointed on
29 November 2003.
29
November 2003.
29 11/2003.
My lord.
Disengagement is
27/10/2018.
No, my lord. Disengage is 19/7/2006. The first disengagement. There are two disengagement.
that was set aside. And
That was set aside.
subsequently again
Again, in 2018.
It was
set aside on what ground?
My lord, the petitioner was engaged in 2003 in pursuant to advertisement of 2003, my lord. A merit list was prepared on 3/7/2003. My position in merit list is serial number 12, my lord. I was selected as engagement order was issued. In 2008, my lord, a judgment was pronounced in WPC 12278 of 2006.
Yeah.
Where, my lord, a letter of the state government that is dated 26/9/2003 by commissioner, he directed the director, you fill up all the other posts which was unfilled in without making any advertisement.
Okay.
That letter was quashed. That letter was dated 26/9/2003.
26/9/2003.
My lord.
But subsequently you were appointed. 29/11/2003 you were appointed.
So I was appointed in November 2003. Merit list was prepared on 3/7/2003. I was appointed out of that merit list, my lord.
Is it your case that the earlier order by the division bench or single bench?
Say that.
11748 of 2003
Single bench.
and 1751 of 2012. Those orders did not impact your appointment or engagement.
My lord. Because, my lord, by that time already a merit list was prepared. I was within the merit list.
Where are those orders?
My lord, can you see the flag F, my lord? Flag F.
One second. Whether now 2018 order by which you have disengaged the services,
yes, ma'am.
on what ground?
On the ground that initially, by virtue of without any advertisement, he was done.
It doesn't say so.
It does not say so.
You look at the order, disengagement. That we have been telling you. Maybe you are holding some other brief, it doesn't match the feelings.
No, my lord. 1825 of 2024, my lord.
Do you want time
Yes,
to go
ma'am.
through? We'll call this matter tomorrow.
My lord. Monday, my lord.
Monday. Maybe many matters we have posted, but all right.
And Tuesday.
But you should, whenever you are not prepared, otherwise we'll be spending a lot of time in this only.
I'm sorry, ma'am.
Anyway,
Monday or Tuesday, ma'am.
in the beginning itself we can say, wherever you are not ready, we understand that you are a government advocate, you will have many briefs at hands. At least you should inform us that we are not ready, take this, that way.
Item 8.
One day we will come up. To produce those two judgments.
Of the single.
Flag F.
Flag F in the writ petition.
Flag F, I file a note along with all documents, my lord.
Yes, Mr. Commissioner.
Actually, in that case, in the sheet of paper I have given, the intra-court appeal,
Yeah.
80 technical education, so far as the referring to air conditioned trade and electrician trade. IIT training
ITI.
Yes, sir. Now then, he was appointed in Group C post, that is class 3 post, actually they call it.
Wait a minute.
That base level post and date of joining is 1/6/99.
Yes.
Then he was promoted, the date of joining Group C post, assistant AC operator on 30/5/2006. If Lordship looks at Brahmananda Swami's case, he was a workman B license holder under matric, joined in 1996 as a helper. 96 subsequently he has filed materials.
1996.
96 as helper.
Can we write, you have not written
I
that?
have not mentioned that, but I'm sorry.
1899.
18.
So 18th of September 96 is in.
Okay.
This base, he joined in Group D post, my lord. The class 4 post.
That Group D workman, Brahmananda Swain,
Yes,
is appointed in which year?
as helper.
In which year?
As a helper prior to joining of the appellant. Prior to that is, I think.
So month it is 1896.
And initially it was in 75.
18996.
In regular establishment, it is 1896.
1996.
In Group D.
1896.
96.
Just give us
Again.
That is in Group D post. That is class 4 one.
Yes, sir.
But if you will see that promotion took place so far as Brahmananda Swami is concerned on 16/11/2001. But prior to that, in Group C post, he was a wireback this petitioner on 1699. That is about more than 2 years before. 2 years, 5 months, 15 days.
Yes.
Then subsequently in 2006, he was also promoted to the higher grade, same class 3 post, Group C.
Group C.
This AC operator, which the petitioner was functioning from 35 2006, this Brahmananda Swami was posted there 24/9/2009.
Twenty-four 9/2009.
About 3 years, 4 months, 6 days after.
Yes.
While promoting to the post of electric mechanic in 2019, the petitioner's case was ignored.
And he was granted promotion.
It was granted promotion. That is the subject matter of challenge, madam.
How the learned single judge viewed all this?
Now, my respective submission is that since the post in which the person has joined is lower than the post actually he was there, his length of service cannot be calculated, but throughout the petitioner has been promoted much before him, prior to that. And he joined in the Group C post, not in Group D. Joining also in Group C and Group D. While preparing a tentative gradation list, they committed the mistake. If you kindly have a look at the tentative gradation list on the basis of which the Honorable Single Judge has passed the judgment.
Any rules, sir, which regulates this granting of seniority? Because your
Yes,
case,
a promotion comes seniority.
We got your point. In fact, when my lord asked me that, in fact, your case is that in Group C, Das is senior than Swine.
Sir, if your lordship looks at,
Is it a seniority come merit or merit come seniority?
says merit, it's seniority come merit.
Which rule?
But if your lordship looks at Odisha Subordinate Electrical Worker Service, method of recruitment and condition of service have been also referred
To
to.
get that.
Rule 2005.
Any copy you have produced?
It's a local act, my lord. That.
Local like volume? Odisha Subordinate Electrical Service.
Yes, yes.
Read rule itself.
You can read, sir.
Can you please read that rule itself?
Sir, Rule 11 says, seniority of candidate appointed to the service shall be fixed according to their position in the select list.
That's the fixation of seniority.
When employees are recruited by promotion and by direct recruitment during the same year,
Correct. In one process.
during the same year, the promoted employee shall en bloc be considered senior to the directly recruited employee, irrespective of their date of joining.
That's we have understood.
Right.
Question is
17, volume 7.
whether is it seniority come merit or merit come seniority?
It's seniority come merit.
Seniority come merit. Where is that stated?
So actually, if your lordship looks at the rule doesn't expressly so, but they do it by that.
Where rule
Sir,
Apex Court says, where rules do not specify, in all such cases, the promotion shall be on the basis of seniority cum merit.
seniority company.
Right. But there is no rule which says to the contrary.
No.
Seniority cum merit, number one. Then second one is seniority in the post, in the feeder category,
Exactly.
not with the entry level. It should be from the feeder category, unless the rule otherwise says. According to you, your client was promoted on 30 May 2006, whereas the other person was promoted
24/9/2009. 24/9/2009.
Now, from here to next level, this all goes, no?
So feeder post is AC operator nerve.
Who appears for the other side?
Government and it is for fresh admission. Government and private parties are also there.
You take note of this, covered by the judgment also. Anyway, just look into Ramajesh has given cited many decisions in support of this rule in his famous book Services Under the State. The issue emergent notice. Learned AGA Mr. Mohanty on request accepts notice for whom? All the official respondents.
No, my lord. 1 to 3.
1 to 3.
4 is private party affected.
Issue emergent notice to 4th respondent. Even that.
4 is Brahmanda Swami. 4 is Brahmanda Swami.
No, private.
Yes.
Reproduction.
Item 9, Your Lordships, this is second round of litigation. In the first round, Your Lordships, may I take Your Lordship? I'm first Annexure 9, page 110, Your Lordships. Which was Annexure 8, Your Lordship.
Page
105. This is our order.
Can you make a small statement?
Yes.
What is the grievance?
Your Lordships, what happened is the INC allows admissions. Indian Nursing Council, I should have said the whole form. Allows admission for SC, ST and OBC candidates with a 40% mark in their entrance exam. Now, what happened in state of Odisha with this INC is, of course, that is adopted and our prospectus goes. They did not give that benefit to SC, ST and OBC people. Then the judgment was passed by this honorable court and they said, no, you have to extend it to SC, ST and OBC people. You can't give them 50% percentage, but 40% you should tell them as
a cutoff percentage.
Cutoff. Basically passing mark for them.
That's what.
But what they did, they did not do it for the SCBC candidates.
SCBC means?
Socially, economically backward.
OBC.
No, OBC they did. But in state, we have it as SCBC.
Okay.
And then there was another round of litigation where they allowed. But the court directed, no, you have to extend it to SCBC candidates also.
Whatever facilities afforded
Yes.
SC, ST.
Yes.
to be extended to
also to the
Yes.
SCCs. But your lordships, all this was happening in the midst of the admission last year in 2024. So all students have applied, but there is no method by which they can say that we are SCBC candidates. So everybody was general. When you don't give that benefit, so everybody is general. So then they gave us just 1 or 2 days of a window to upload, and there was no wide publicity of this judgment, because of which many of us lost the chance to show that we are SCBC. Don't consider us with 50%, but give us that benefit of 40%. Now, what happens is, your lordships, first the government seats are filled and then the management seats are filled. We took admission and a management seats. And what normally happens is the college is supposed to then upload your documents or give a hard copy also. They gave a method of hard copy. But the DMAT refused to accept our admissions. We came before this court. And the first round, the court said, no, you extend the same benefit. Just ensure that the college has taken that admission within the due date. Now they reject my candidature on this ground that no, you had not uploaded and you are not eligible when you don't meet the percentage. Obviously, I'm less than 50%. I don't meet the percentage because you are not considering my status. So the only thing that the first round of litigation said that you only examine whether you have taken admission within that cutoff date. But as far as these two aspects is concerned, they are a SCBC candidate. They deserve that, consideration on that.
In your application, did you say that you are SCBC?
Yes, in the first, the application to the
because judgment itself.
Yes, yeah.
So just say
in that format only.
Only one question, maybe technical rather. When they say you did not upload, does they say by any date? Because there is no scope of uploading till the judgment.
I would understand that probably they are saying about the 2 days window.
Yes.
But then that's exactly what got decided. That was their case also in the first round of litigation. That is exactly what the court got decided.
Decided in your favor.
Yeah, because that was a completely a very small window.
Their uploading becomes irrelevant consideration.
Correct. Fresh
Yes.
uploading.
Yes, uploading has to happen.
Okay.
But have they taken that stand, or it's a fresh?
They've taken that stand, your lordship, now at annexure, page 121.
121.
Annexure 12, your lordships. Starts at page 120. 121 is the finding portion. I'm the first one.
Within deadline, it did not happen. The judgment was rendered on which day?
19/3/2001.
Let me come to that. I'll show them. Where was it?
Ended up 11/24. 26/11/24.
Compliance after judgment.
They soon.
Annexure 9.
11/24.
110.
Deadline is 29/11.
Your lordship, you look at 110.
110.
After the judgment, that initial judgment which came in the favor of SCBC candidate.
I'm looking at that. 11.
27/11 and a 2 days window only.
And 29/11 is the last. Invited us them to
Why that short period?
Because they said that the INC by that time had said that after November,
What is
Annexure C.
What is the Supreme Court's deadline? Because in these kind of matters,
Yeah,
Supreme Court has
INC had a deadline. That is why they said we will do it within those 2 days. But the first round of litigation which we fought, the court was of understanding, yes, the guideline applies.
You should have paid for interim order.
No.
For allowing us to.
No, we had taken admission. We had
You were
In
taken
admission, but
admitted in a
that-
private college.
private college in management.
but in management sits in general category.
Yes, Your Lordship.
Till 2024, when the court said that yes, you have to extend the benefit to ACBC candidates. That date, you didn't get a chance actually, but maybe by court order it could have been possible.
No, what the court during the first round stated that yes, there is a deadline and Supreme Court has asked you to stick to the deadline, but it is under the presumption that the state does everything correctly. The state was not giving the benefit which the reserve category candidates were supposed to get it. Your Lordship, the finding of the first round litigation, Your Lordship will see is at page 118, para 9. This was our first.
Any possibility of extension as per the Supreme Court direction?
That's what exactly what the court said. The court actually did not accept their argument because it you.
But then court should have said that you accept till such and such.
Yes, no, the court said this, Your Lordship. May I just read it? It is true that para 9, Your Lordship, page 118. That's the first round. It is true that many seats in BSc nursing courses are still lying vacant in different private colleges admitted by the parties. What is contended on behalf of the petitioner is that they have taken admission under management quota in the month of December in different private colleges and pursuing the studies by attending till date is not disputed. So in such peculiar circumstances, taking note of the fact that the petitioner genuine candidates under SCBC category who could not apply their candidature online before the last date, we leave it to the discretion of DME to take a decision with regard to permitting them to appear in the examination concerned, provided that the institution have taken the lawful steps to intimate the admission of the petitioner to concerned authority. So this is all that DMET had to do. What DMET did is repeated its stand that it had taken in the writ, that we will not do it.
The last slide, just read them.
The decision shall be taken by DMT within 30 days from the date of receipt of the certified copy of this order. 19/3/2025 was the annexion.
Allowed for examination of each semester or year semester?
First semester.
You produced these documents on which date?
My documents were there with the college, but
About the cash date?
yes, the college had idea about my caste certificate. The only problem was that 40 and 50. And they were making that
College intermediate admissions to the
DMT, yes. But DMT said that I will not accept it because it is not within that 2 days gap that we had given you. And DMT said I could not have given you more because I had to reach that deadline. But then I'll also show a document with DMT Somota also has been violating.
deadline regarding admission or examination?
Admission.
But this is the court says regarding examination.
Because by that time examination was also appearing, so that's why the court also said. Basically said that you accept the candidature now. Allow them to take their examinations.
If your admission is taken, can it relate back to the deadline of Supreme Court?
Your Lordship, that's why
That process.
That's why
The thing is crossed.
I would.
Madam, in the case I'm appearing for the number 5, the Indian National Council.
Yes, and but we have also served copy to Mr. Mahanti.
DMT is OP number 2. DMT.
That will be the main.
State is for 1.
Yes.
1 milord, because DMT Mr. R. Mahanti is appearing.
He's here. Mr. Mahanti is associate.
D.
He also, Mr. Mahanti will take. No, Mr.
2 and
R.C. Mahanti Junior is here.
2 and 2 and.
Why have we made this?
Arshima.
Or somebody else.
This is government.
Notice will go.
No, Ajay Kumar is senior panel.
What is the influence?
University.
For 1 and 2.
The college is the necessity.
Now the examination schedule hasn't come out. The moment comes, then then we'll.
College should
say that yes, we have achieved.
We had in fact last time provided documents.
College has uploaded the student into the DMT office. So much after the cut-off date, that is 31st,
2020.
November.
Let me just show that.
Thereafter, they have uploaded. They are now
Admission cut-off date.
the admission cut-off date was the 30th November. Thereafter, they have uploaded the. But they are claiming that prior to that they have taken admission, but college has not.
Uploading the subsequent act.
Subsequently uploaded.
Unless you say it's an online admission. Yes, it's an online admission. Uploading has to be subsequent. Your argument will not survive there. Your first argument should be that it is online admission. Everything happened online. And it did not take place by the
No, that is not online admission. Admission in the
In fact, Mr. Mahanti's submission is contrary to their own notification at Annexure 10.
Item 10.
Yes, brother. State versus union.
State versus union. That I have solved the copy as per the earlier order, my lord.
What is this matter?
This matter is about that winding of proceeding, the challenging the order of the CMPT order 4 of 2022 under Annexure 4 at page 50.
Annexure 4 at page
50.
What that order says?
Order says that the third party in favor of whose this industry, which is the Sikh industry under the BFR, so for the land and all other things is to be handed over. But fact remains, out of that 104 acres of land, 60 acres belongs to the forest, under the forest act. Yes, madam. So this cannot be all the way transfer alienated to the
Because of
Godavaran case. That is the only ground, my lord. And without taking
Godavaran is a limitation on transfer or the change of kisam?
change of kisam, my lord.
Then transfer, I think, then you are
No, no, but
you are having transfer.
But it comprises of 109, my lord. Out of that 60,
09 private.
total.
09 company property.
Yes, ma'am.
So that does Godavaran come to your help to argue that out of that 60 acres cannot be transferred without changing the kisam.
Without changing the
Cannot be
kisam.
changed.
Yes.
The nature character of any land recorded as
Forest kisam.
records cannot be changed.
Cannot be
But you are saying that it is an imposition because that would be contrary to rule against perpetuity in Transfer of Property Act.
Yes, ma'am.
That does not apply to state. Section 14 of the Transfer of Property Act does not apply to state. New point. Have you seen the doctrine of the rule against perpetuity? Section 14 of the Transfer of Property Act.
I have not gone through
That you have to look into. Section 114 of the Indian Succession Act and Section 14 of the Transfer of Property Act. Both you have to see and come back.
And the point in your favor, what fell from my lord is that that also, when the court rules, that doesn't apply to government.
There is one such judgment by Justice S.N. Mukherjee of Calcutta High Court.
But that doesn't answer it.
Because
it
there
raises
must be
more
that-
questions.
That's one. Just look into it and come back.
Yes, ma'am.
You also.
Then how the learned company judge has dealt with that? If at all that was considered.
That's it. That's it. Not, huh?
For limited not taken.
Yes.
Sorry, we didn't know. Steps for limitation?
And that has not begun so far.
Then
This.
no delay. Then mistake. The noting of the staff report regarding the list section. Who has put that proof? Delegate staff.
I said that.
Letter contact by letter contact by letter contact
Oh, delay?
No deals. IA is not, IA fails into IA application in IA number so and so supported by affidavit seeking condonation or delay. Bail is insignificant.
Sir, no application is
There is no application for condonation to.
It's condonation of this. No, not at the court first, now people. Then so you will say that the appeal is in appeal is filing. It's what's the writing of this conclusion? Not is there. Like a single judge has not referred to that rule against perpetuity.
No.
Sir, here is the resuming hand, 1140 days.
What do you say, brother?
1140 days delay.
Because it is dated 22 February 2022, my lord. This impugned order and subsequently,
But you have filed appeal on which date?
this is 5/5/2022 is the impugned order, my lord. Okay,
Yes, it is correct. Presented on
it was
725.
yes, ma'am.
Going right.
Then the application is not moved.
Actually, he has scoped through the.
It was 26 22/6 to
Scoped through this. Again, written in hand. So I saw the scoped through page.
22/6/2000.
The learned counsel, the learned AG appearing for the appellant submits that he shall take steps for taking steps for condonation of delay as wanted by the SR. That is 1140 days. 22 ରୁ 25 ହବନି?
But the same was presented. They have dated 26/2022, my lord.
Appeal.
Yes, my lord.
The order was not produced.
My lord, later on, because at page 50 can have a glance.
Condonation for the intention of firing the Medco. The staff report has written in the staff reporter has written in the staff report that the judgment is dated 18/7/2025. The judgment dated 5/5/2022. Date of filing to be 18/7/2025.
This is 26.
The office note put up by the registry indicates the date of presentation is 21/6/2022.
Yes, sir.
The matter shall be placed before the Registrar Judicial to do the needful regarding the correct stamp reporting. This all.
It is not making time only then.
It's on 29th.
Then it.
It's on 29th July 2025.
Item 11.
Was permitted 1 week time to file. Was permitted 1 week time to file requisites in respect of the ELRs of the deceased. Respond number 21 will also.
21?
Respond number deceased. Respond number 21 to the PLR, to his PLR will also. It was directed on 4/2/2025. This Honorable Court is pleased to direct.
You have to take now. You have to take steps.
You will also
Take once extension of time.
2 weeks finally for taking steps filling which appeal steps rejected.
Taking steps in terms of the earlier order dated 4/2/2025.
Item 13.
This is a work charge employee regularization matter where all the matters, similar matters, so Lordship have kept for 4th of August for analogous hearing.
Call this matter on
4th of
but
August.
the notice is not at all.
No, notice.
Service served. Yes, madam, you sister, you appear for
Yes,
respondent?
Yes, sir.
Appeared.
Call on 4th of August along with connected matters.
Item 14.
But on the merit, my lord, we have assailed the order of the Honorable Single Judge on the ground that in a similar matter, the Honorable our High Court in a writ appeal has interfered in the similar order where the Honorable Single Judge Lordship has page 11, that is the impugned order, running page 11 of the writ appeal brief, where the Honorable Single Judge has relied upon one decision, Subhash Kumar Baral, and has opined that revision is not maintainable under section 32 of the Odisha Survey and Settlement Act. But later on, my lord, in a writ appeal, we succeeded by challenging this type of order.
This appeal is reversed. The Subhash Kumar is reversed.
No, yes, this has been reversed. In Lordship, kindly have a glance to this. Rai, Santosh Kumar Rai matter. Santosh Kumar Rai matter, and Lordship have Honorable Court has opined that revision is maintainable. Servant settlement.
They refer to the earlier this judgment where?
No, it has not.
Or it is a similar order.
Similar order, but not been referred. Para 6, your lordship.
Do you have copy of that order in WPC 1768?
Yeah, that is what
So revision is maintainable.
No.
But this judgment proceeds on the assumption that revision is not maintainable.
Yes.
Because of that earlier order.
Day before yesterday, this matter was also there. Keeping in view that earlier judgment under section 32, which culminates from 22 of the Servant Settlement Act. So in earlier, Honorable Single Bench has hold that this is not maintainable. But subsequently in this judgment,
Yes.
it has been decided that it is maintainable. In that matter, my lord has issued notice on that.
No. Because they have to appear, my lord. They have to appear.
Day before yesterday one.
Issue notice both on limitation and merits.
Item 16.
May I please, your lordship? This is a delay, my lords, delay of 11 days. It's a admitted dues under voluntary retirement scheme has not been paid. The appellant was relieved on 31/2002. Thereafter, approached this honorable court in the year 2007. This honorable court also, honorable single judge directed for payment. The matter was assailed before honorable apex court. Apex court also confirmed, my lord, saying that you pay. Thereafter, they didn't pay the appellant a single rupee, my lords. The
My
matter
lordship, may kindly see the impugned order, my lord, at page 35. Why the honorable single judge has not granted the relief? Page 35, order dated 6/8/2024. Because the liquidation process was on, my lord, and they have arrayed the official liquidator as a party. Paragraph 3 of the judgment at order at 36, page 36. They have been allowed to move before the liquidator.
No. May I complete, my lord, kindly? My lord, liquidation process is in 2005. Let's see.
Saying your favor. During process of liquidation, whether the lead court has jurisdiction or you should go approach the liquidator for your claims.
Yes, my lord, but since liquidation of this particular mill is since the year
So now,
2005.
let us assume date is maintainable.
2005.
What ultimate order will be passed in a proceeding where liquidation is done? That's my question.
Yes. My submission before your lordship is liquidation proceeding is in 35/2005. In the year 2007,
When the winding up order was made?
2005, lordship. In the exact date, my lords.
2005.
Yes.
But winding up is a process.
Yes.
Whether the company is wound up now?
Yes.
When it was wound up?
But that, in fact, my specific submission before the honorable single judge was page 100, lordship. And that was the annexure 9 before in the writ petition. After liquidation process, the mill was under liquidation. By virtue of these judgments, my lords, are passed by the honorable single judge as well as confirmed by honorable apex court, liquidator has paid these dues to co-employees, my lords. And this is admitted dues as per page 69, my lords.
No, even otherwise.
Yes.
The dues of an employee carry pari passu.
Yes.
They have pari passu on that. You will have preferential claim. There the one judgment, na
Very passu.
Section 529
Of the company.
of the company, 529 capital A. Give companies a gold.
Differential claim.
Mahanti, if you say so, then that is another argument against you. You say that the official liquidator has already paid some of your colleagues similarly situated.
Yes.
So he says then you are supporting that.
In page 69, that is there. That was
Then
mentioned.
the read code is correct in saying that you go before
But
the
I
liquidator.
had in the read me lords, page
Suppose
126.
any order is passed by the liquidator, you have to challenge that.
Yes, but at page
Before the
126,
company appellate, company court here.
page 126, my lord, I have approached the liquidator.
Then what happened?
He was silent, my lord. And thereafter, in pursuance to this, my lord, state government issued a clarification.
That should have been your prayer before the read code that single judge that
Yes,
is
I have-
sitting over it.
And I have two prayers before the. I have
What the state government said?
That's a state government, my lords, that my application before liquidator was at page 126, my lord.
No,
For my dues.
what my brother says.
Yes, Annex 16 page.
Company is in the winding up process. Winding up process is a very long process.
Yes.
Whatever claim, once or company is ordered to be wound up,
Yes.
all claims have to be addressed to the liquidator himself.
Yes.
If liquidator has already made payment to rest of your colleagues,
Yes.
why you did not approach the liquidator is the question of my brother.
Well, it's liquidator after payment, my lords, after this application was before the liquidator, my lords, at page 126, state government replied to me that I am not eligible to any amount.
The
other way of looking at it is that how can we interfere in an order which is in your favor? It says that you go to the liquidator.
Yes.
So how the appellate court will interfere with that? You do not go to liquidator.
Lord, that thereafter, lords, the state government 127 page, lords, you kindly see. State government said that as per report, lord, I am not eligible for any further amount, lords. And my specific case was.
So how much you have already received?
Lords, I have received.
That was the query from the esteemed senior that what was the stand of the state? State says that you have received so much amounts and no further is. Then how can the read court can adjudicate?
Lord, at the time of
in a company proceeding where it is already wound up, or it has started and it's in the process of being wound up.
At the time of relief, my lords, I was paid 2,43,000 in the year 2002. Page 43.
That was prior to the initiation of the winding up proceeding.
Yes.
So from 2002, then after accepting that,
yes,
did you raise that grievance that it
yes,
not the
yes, lordship. 2007 read petition is there, my lords.
No, the company law says.
Yes.
Once company is ordered to be wound up,
yes,
the liquidator is your opponent. And no proceedings can be taken up without liquidator at all. There is such a section 444, something like that. I don't correctly remember. There is a Ramaya on company law has made full discussion on this aspect.
Yes.
A. Ramaya says, referring to various judgments, wherever your claim arises against a company which is ordered to be wound up, you have to make the liquidator a party to that. No other person can represent the company, not even the government. Though it is a government company. Is it a government company?
Yes.
Section 520.
Yes, it is a government.
Cooperative society.
Cooperative society, my lord, registered under.
Cooperative society.
Major stakeholder is of government.
It is ordered to be wound up. Cooperative society, not company.
No, cooperative society, 95% equity share.
Suppose you have distributed the resources.
Yes.
You got 2,40,000 in 2002, 33 years back.
Yes.
And some and all, it has been, equal distribution of available resources. That way also.
That is called the rateable distribution. Doctrine of rateable distribution. Suppose if company is holding 1 lakh rupees asset, but the claimants are more than 1 lakh. Then a rateable distribution happens. One who has paid 50,000 may not get back 50,000 at all. It will be less than 50,000. Therefore, larger issues are involved. And learned subject said, go before the.
That I have gone. I have twofold submissions before your lordship also.
But again, inaction of the liquidator again is not just beyond WA.
Yes,
or he rejects your claim, again company court.
Company court.
Read court could have directed that expeditious disposal or appropriate consideration. Suppose there is any delay, let us assume. I'm saying that you delayed. The court could have condoned that it shall be considered. But we do not know what order has been passed, what has happened after on your application way back in 2018.
Yes.
No, sorry, 18.
Yes. This was the second round. 2018 is the second read petition.
Whatever.
But whatever single judge, let's you kindly see page 148 for a moment.
I mean, is it further another? I mean, maybe it's also significant.
Let's see.
When you got 2,000, 2 lakhs, 2,000, what was your total claim then?
Well, that is admitted, that is 4 lakhs.
Who admitted that?
The managing director of the mill.
So what? Managing director is not paid.
No, managing director.
So when you were paid 2 lakh 2,000,
yes,
after you were successful in the Red Court and then in Supreme Court, thereafter whether the subsequent claims,
yes,
or the residual claim as you may call it,
yes,
can be a subject matter of the liquidation. Proceeding before the liquidation. That will be another issue also.
Yes, let me clarify, my lords. Page 68 for a moment, my lords. Page 68. One second. Lords.
Is it a company or a cooperative society?
Cooperative society, my lord. Cooperative society.
Cooperative
Government society.
What is the procedure for winding up of the cooperative society? Because cooperative society is different from company. Since you say company, I was looking into the company side. What is the procedure for winding up of a cooperative society? Is it on par with the company?
In the Act.
Act. What is that?
Cooperative Society Act.
Yes. If it is cooperative society, then how liquidate? What is the liquidation process under the Cooperative Societies Act? Is it on par with the companies?
That will have to
At least in our state, in the state from which I hail, it is not like that. But I do not know what is your state cooperative society is.
There is a provision, and the Supreme Court has directed that. In SLP 5484 of 2010, or dated 24/3/17.
Yes.
And notices to all the farmer employees that the above liquidated organization, spinning mills, as for the direction of the Honorable Supreme Court, the arrears shall be paid.
Because in Ramakrishna, you have not read, that is the problem.
Yes, no.
So you are senior to me, I have to say that inevitably I have to say this. The dues of workmen enjoy pari passu, whether it is under the liquidation of company law or liquidation under some other law. There is Ramakrishna versus so and so. Which aspect is considered by the apex court?
10, winding up and resolution of societies. 22,
Priority of contribution. This priority is pari passu. Powers of liquidator.
103.
Because Ramakrishna Menon, etc. Head of that Ramakrishna Menon versus so and so. 1980s Supreme Court. Pool or ratable. That is the thing of ratable distribution. But ratable distribution, they enjoy pari passu, therefore no ratable distribution. That's what Apex Court said in Ramakrishna Menon. That was under the Companies Act, under section 529, capital A. Section 74 Act. Priority of contribution assessed by liquidator, not just anything contained in the provincial insolvency, the debts of the society under Order 552 being wound up, and the grant next to the debts due to the government or any other local authority not to pay. It's a Supreme Court judgment. I only remember when Ramakrishna Menon. No, it's the Supreme Court decision itself. Or it is Ramakrishnan versus so and so, just looking. Only government is entitled to have pari passu under section 74 of the Act. Therefore, you also suffer rateable distribution. Contribution next to debts due to the government or to local authority in order of priority in insolvency proceedings. Just look into and come back. We will not watch any other. Then powers of liquidator. To pay claims against the society, including interest up to the date of winding up according to their respective priority, if any, in full or rateable, as the assets of the society may permit the surplus, if any, remitting after payment of the claims being applied in payment of interest from the date of such order of winding up at rate fixed by him, but not exceeding the contract rate in any case, to determine what persons. So under section 75 clause D, you can raise the claim before the liquidator. But just look into it, because this section gives priority only to the government dues and dues of the local government. But Apex Court said, since the workers' sweat enters the commodities of the company in question, they should have pari passu. That's what the Apex Court has said. Just
in this case, my lord, the Apex Court has already given a judgment.
In this case, yes.
In this case,
saying
the SLP. Saying he should go before the appropriate forum. Whatever the government has to do, government has already done that.
Let me clarify.
Lordship, page 136. Page 136.
Yes, sir.
Page 136. It is stated that the dues of the employee to the tune of rupees.
Just give us a moment.
No.
You get there.
136.
Yes, 136.
That's page 133. The right hand corner, double marking is there. This is
yes, you have to go before the liquidator. You cannot say anything more than that.
No, let me clarify that word, that order. My learned friend said.
Yes.
State was the petitioner before the Honorable Apex Court, my lord. It is the state SLP challenging. Also, one of the SLP filed against also a case filed by this petitioner also. That is SLP 2885.
The order passed by this court was put in challenge by the state.
Yes,
in SLP.
Yes, I'm only 104 page 104. This is the batch of writ petitions which were disposed of by this Honorable Court, including the case of petitioner. Page 104, earlier case.
104 is High Court order.
Yes, and if your lordship will go to 107 page, my number is 6875, second row, 6875 of 2007.
Not disputing that.
No, only my lords, I am clarifying because there is some catch, my lords. 6875 was my case, and matter was carried to Honorable Apex Court, my lords.
You say the SLP order is not binding on you.
Yes, Honorable Apex Court said also to pay the dues. Rather, they said they didn't pay me. I was before Honorable Apex Court. I appeared before the Honorable Apex Court. My SLP number was 2885 of 2011.
Is there any separate order then? Is there any separate order in your SLP, or this is the only order passed by the Supreme Court?
First order is page 115. That is the first order.
In this sense, by the High Court or the Supreme Court?
By the Honorable Supreme Court. The first order.
115.
Yes, let's.
This brief.
Yes. And this SLP 5484 of 2010 middle one is also a employee of this Sarala spinning mill.
Another employee.
Yeah, of this spinning mill. This was the leading case. 3 SLPs were there. And this is the order, millers. Page 116.
But I think it's the same SLP, State versus Purnachandra Sahu.
Yes, State versus Purnachandra Sahu. Next one is 5484. I will come to you. Let's to this on that page. Yes.
Was he appearing in the SLP?
Let's see.
But my name doesn't appear. So
No.
Don't take exception to that.
Yes. I am conscious, my lord. I am conscious. So far these cases are concerned, my lord. No. Page 106, my lord, Honorable Apex Court said you pay the dues. So far as...
Yes, 803, 7.86.
Yes. They said you pay
50% to be paid.
50% within first installment, then 50% within 6 months. That is the order, lords. Kind signatures. May I permit place, lords? Having regard to the facts, circumstances of the case, we are of the view that appellant, one state appellant, ought to disburse dues of the respondents to the extent of 50% out of proceeds of assets of the sick mill in question within a period of 2 months. The remaining amount be paid within a period of 1 year thereafter. Any pending litigation in this regard may be concluded as far as possible within a period of 6 months from today. It will be open to the petitioner to take further steps. Petitioner.
For getting any pending.
Yes, it is state is the petitioner that I bring to your lordship's notice, my lord. Thereafter, my lord, what they did, my lords, page 118, my lords. That is the batch of matters. Page
180.
Yeah, 119, lords. 119. That batch. It starts from 118.
In that you are also there.
Yes, 119. My SLP is 2885 of 2011. My lords, 11 numbers from bottom. Page 119, lords. SLP C.
In terms of order dated, so it is there, all they are disposed of.
Yes, 2885 is my SLP. What they have
you say is Apex Court said the appellant said to make the payment.
Yes.
They are bound to make the payment.
Yes.
Your contention. But will not be driven to the liquidator at all.
Thereafter, lords, Honorable Single Judge, there was contempt. Honorable Single Judge also said right at 123 page.
Brother,
said to comply.
Wanda, there is a judgment of Apex Court. It did not say go before the liquidator. But Lord Single Judge is saying go before the liquidator. Where he should go? He says Apex Court of the country has said.
But in subsequent judgment, your lordship, the petitioners are.
The next judgment, the next SLP.
By this judgment, yes.
But there are later on, 128 or something.
No, there is no further judgment. These are two. 128, let's see.
Yes, 130.
Same one, let's. Same one. Same one. Same is at 118 and also at 130. Yes, same one, let's.
136, I will say.
Yes.
136.
Yes. Because there was a communication from the state enclosing that judgment and saying that also I am not eligible for any further amount.
State name, that is also continue. State versus Purnachandra.
Yes. State versus
How 118 and 135 are different, the same or what is the difference?
118 and well, same one. 1118. Well,
36.
no, that is state versus Purnachandra, sir.
Same.
Yeah, that has been communicated, so I have enclosed by the state. Same judgment.
Judgment and the other judgments.
Yes, Lordship. This is SLP Millards 354.
Lordship, may kindly have a glance to 129, page 129, the government order which is assailing in what we have stated, my lord. In the last paragraph of that order, paragraph 10, the internal page 90, running page. Since the government in HT and H department have already taken steps for releasing your admissible dues as per the orders of the Honorable High Court dated so and so, passed in contempt petition number so and so, and the order of the Honorable Supreme Court of India dated 3/7/17, passed in SLP number so and so, and connected cases, no further compliance is required by the contempt.
What is meant by that? Where have you paid?
Yes, 50% below.
50% he has received.
Yes.
The remaining amount within 1 year.
I have not received a single pie, Millards.
You have not received any amount.
After
You
2007.
are saying 2000.
That is in the year 2002, Millards. At the time I was relieved from service.
2002.
2 Millards. When I was
How much
relieved.
money was due to you?
Millards, that is admitted, Millards. Page 30. That is through my case.
How much money? Just
Yes.
spell out the figure.
Yes. Page Annexure 5 is the Annexure 5, page 66, Lordship.
With backing the
Yes. That is 4,10,000 Millards admitted.
4,10,000.
Yes. I have not paid 1 rupee out of this.
But earlier you received how much?
2,43,000.
Totally how much was payable?
Well, 6 lakh some.
So out of that, 2 plus is paid to you.
Yes.
This, yes, Mr. Panda, what about this? No, you can't say like that.
I have to obtain instruction, my lord.
And you understand the sequence also.
We were under impression it was a liquidation under the Companies Act. It is not. It is under Cooperative Societies Act. Correct. This is the judgment. Just look into this judgment.
And
National Textile Workers versus P.R. Ramakrishna.
I'm grateful, which
Yeah.
I could.
They are in 83 Supreme Court, 75.
And it.
Workers, it would say how to report.
1983 Supreme Court, 75.
Grateful, I just okay. Yes, grateful. Millards, I didn't. In that way, I have not. In fact, Millards, what in the total 5 years, they didn't choose to file any counter in the writ petition.
Yes.
And my case was on the.
No, by saying the learned judge,
Problem was that
steps are taken to
have
make
also raked up this issue of liquidation.
what kind of
Millards,
You told the court that the liquidation is pending.
Millards, because since 2005, Millards,
He has arrayed the liquidator as a party. He has arrayed the liquidator as a party.
One second. A contempt court cannot say steps are being taken and therefore no further compliance is required. No, what is meant by that? What he should do with that order? He wants money. That contempt order is thoroughly bad order, with due respect to the judges who have passed. Unless when the litigant comes to court, he wants some property, he wants some promotion, appointment, money, and the protection of reputation, maybe sometimes spouse also. Is it not? Saying that when there is such an order, if the contempt court says all steps are being taken in that direction and therefore compliance is reported. What is meant by that? Complaint is not, money is not paid to me. With the court order, you cannot buy even half a dozen banana in the market. With the money, you can. Therefore, money has to reach the hands of the employee.
and more pitiable thing is that on the plea of case SLP,
Let him come back to this.
delay was there.
Just look into that judgment also. The Companies Act is amended in Old Act. Section 529 capital A came to be introduced by the Parliament.
Yes.
That's what A. Ramaiah on company law. It's a standard book. Just go through. That helps you. Yes.
Date may be fixed.
Yes, we'll fix the on 21st of August.
Delay was there, and one party is that
We'll condone the delay.
No.
3 notices.
Appeal is moved is with a delay of 140 days.
No, 11 days.
11 days. A short delay of 11 days. And explanation is offered in the application supported by affidavit. We find the explanation to be plausible. First, in the above circumstances, application having been favored, delay is controlled. Yes.
Item 17.
Private, you will say private.
Private this will not this state accepts 1, 2.
Mr. Pandal and AG appears 150 short for 1 and 2 waives notice.
Yes.
3 and 4
I'll take note.
notice by registered oblique speed post requisites within 3 working days, 5 working days.
Great floors.
5 working.
Great floors.
Item 17.
Yes, please.
Same.
For is same as that batch.
No.
Separate.
It's a regularization of a driver daily wages millers. At the first day of admission, the Honorable Single Judge has passed order.
Mahanti, when you are raising this, you are correct. Yesterday also. But our concern is that by now, if you file that counter or whatever stand you have taken in
Yes,
the
ma'am.
field,
Yes.
is it sufficient or you still seek a chance?
Well, I'll still seek a chance because I'll file certain documents.
So then you should have completed by now.
Yes,
Because
ma'am.
this process is going to traveling to Supreme Court, again remanded back yesterday. And we have to hear it again. And your first argument is correct that on the first date, the matter has been disclosed.
Yes, ma'am. The Lordship see that annexer.
When was he appointed?
It's appointed as a Delhi Ojar Millers 19/5/2008. 19/5/2008.
2008.
8.
Did he cause any accident? No accident. So driver, good driver.
Driver. Because having, as per the.
Or you want the driver to come to drive your car?
I have stepped there.
Is sales tax?
No, self-driven. Self-driven.
Sales tax already have disposed of drivers.
Your Lordship,
Commercial tax or sales tax?
see that page 32.
2008 to 2025.
Lordship, why I am saying that, Millers, there is a rule prevailing in that appointment of driver Millers in a regular post or sanction. There is a rules, Miller. I will show that rule. But your Lordship, see that page 32.
Education. The problem is that in our society, those who drop out from school, they start driving and they are the best drivers. Then the
So there is a, if you enter into
the problem is that when you recruited him for his driving skill, you did not insist him to pass that education.
There is a government establishment, there is a rules.
You are putting the cart one before the horse. When you appointed or engaged him as a driver, you did not ask for his certificate.
And when required, that is there. Lordship, see that that is
So you complete your feelings first. Because
whatever documents
you want to file and serve it.
I have filed all the documents. I have filed all the documents. Lordship, keep it on some other day.
How much time?
20th of August?
Yes,
right? Call on 20th of August to complete the pleadings. And intended pleadings as well.
Copy this out.
Yes.
After filing. Complete by 14th of August.
I'll file the regular counter.
Not exactly counter because you are the
affidavit. In shape of affidavit, I'll give.
Affidavit, whatever you bring on record so that they get a chance. Because their contention is that even today also they have to wait. And they are genuine.
Make you order 41 rule 25 is also applicable, not to 25, 26 to writ appeal. I saw other day High Court.
Additional evidence.
Evidence.
May I beg your pardon?
Item. Yes, sir.
Next matter, item 25. I am for the appellant.
I am for respondent, Mr. Rothschild, not well today.
Senior advocate is suffering from conjunctivitis.
Not well today.
So he also telephoned me that he will seek.
3rd of September.
My lord.
3rd of September. At the request of both the sides.
Judgment dated. Disclosed to the judge. Disclosed to the judge.
With your lordship permission, item 47, that proposal for mediation. That my item 47, once there is a both parties are appear before lordships and they have denied to reside in simple. So mine
not interested.
Regular matter September 1st.
For the respond appellant.
Appellant man.
Mr. Acharya,
My lord.
this is in that heading. Please mark the heading.
Again.
Special mediation right, petition for the nation initiated by the Honorable Supreme Court.
Again.
So if it has yet to be, no, kindly, I hope you think that I have understood what you have. Has it ever been referred to mediation?
They have come to people or see.
Item 41.
NIT.
Who are appealing for the other side?
NIT.
NIT is represented through by DSGI or other.
Last time DSGI officer taken notice.
So if you can bring them, you can inform the DSGI and if they are present. Wait for some time. We have some personal appearance matters that could be. So
maybe last item before lordship's rises.
If not, kindly inform.
You
bring your friends also.
Grateful lordships.
So Acharya,
My lord. Then your lordship fix a date.
Scheme, my lord. The impugn, I'm challenged in impugnator unless 6, running page 43, my lord. Running page 43, annexure 6. The learned
rehabilitation, Mr. Sahoo, now after that amendment, 25th amendment.
It is old matter, 90 matter.
Correct. So
1690.
So in fact, that's the concern of the court because we have already disposed of the matters where they will consider in terms of the new rules. We have already held in so many cases. We have passed orders in these kinds of matters. And since this is of service in the judiciary, the establishment of judiciary, petitions are coming before the division bench. Are you aware of those orders?
New order.
Sir, copy. You share a copy of that order.
Yes, madam.
Okay, we'll have this matter in the second week of August. Covered by judgment. If you agree, we will say matter is disposed. Are you agreeable for disposal of the matter? Just go through that. If there is any nuance, we will not be able to.
So you can Sahoo for the KRISHNA, Mr. Pandayatra, London ASC for the opposite party, London ASC for the state also have a copy of the order, judgment and order passed by this bench in similar matters dealing with rehabilitation assistance scheme. That is in both as per amendment in 2025. Will it give, sir, how much time?
Second week.
So more second week of August. This talks 12th August 2025.
Lordship may mention, indicate the WPC number.
Correct.
That is 15193 of 2022.
Correct, which you had argued that
Yes.
was not. Kindly receive that copy. You just download that copy. Yes.
Now we do not know actually what is your case, but if that takes care of, so let us leave it there.
Let me examine.
Item 30,
Lord, as I mentioned in the morning, item 30 may be taken up week commencing 4th of August. Because, my Lord.
What do you say?
On behalf of Mr. Patnaik, I am appearing in this case, Your Lordship. In this case, my Lord, from 2010, I have been deprived of getting my legitimate right, Your Lordship. From 2000. The small point, Your Lordship, here, after the death of the deceased, whether the wife is to get that benefit of the death, benefit
or pension or
no, madam. Probably insurance.
My Lord, may take it on 4th of August, Mr. Das will.
And Your Lordship, kindly will grant the
Do you have seen that judgment?
Yes, ma'am.
Some Nilavati, something like that, na?
Yes, sir.
Nilavati.
No, my Lord, this is Saravati. Lordship, kindly will grant to order 2, Your Lordship. Order number 2.
Since he's seeking a last chance.
Yeah. Final. On
Item 32.
Humble submission is that I'm repeating for
there appears to be some amendment. So after the amendment of Apex Court, LIC Act is amended. Just look into that.
9(7) is amended.
Amended.
But still then, that was extensively hard, that matter is not again listed. The difficulty is that
Item 32.
humble submission is that I'm repenting for the appellant. So due to weather condition, I didn't able to appear physically in front of you, Your Honor. So from Bhubaneswar Court, I am appearing through virtual. So my humble submission is that this writ appeal is derived from the. Can I speak, sir?
Today may not be possible because we are commencing another connected matter.
and other also, better if you come physically.
No, sir, sorry, sir. Can you move on, Sorry, sir.
Next week, my lord, any day. We'll have it. But in the 3rd week of August, we will have that.
20th August, Mr. Acharya?
Okay, sir. What?
August, we will have that.
Departed 20th August.
I pray earlier that matter.
But already many matters we have posted. Otherwise, we will have.
Next hour matter is already there.
Because the order has been passed. The petitioner was allowed to participate in the examination, 4th semester LLM examination, who has a brilliant career and is a judicial officer. He stood first position in Odisha in judicial service.
5th of August, we will have. Okay.
Item 33.
Yes. Others may not wait. Perhaps this will take its own time. Is it not?
Yes. But in this batch of writ appeals,
Yes.
Lord, I am holding the plea for the writ appeal number 857 of 2024.
857 of 2024. Yes.
Now, Lord, here the Honorable Single Judge has passed.
No, why you went to the single judge?
Yes. Lord, the petitioner in the. Lord, there are all.
You are a respondent in the
opposite
before the single judge.
Yes.
Yes.
So in all these cases, my Lord, the private respondents are the.
Put on mic.
In all these writ appeals, my Lord, the private respondents.
Why mics are not working? Our court mics are not working. Yes, start.
In all these writ appeals, my Lord, the private respondents were the Delhi DLRs, my Lord, Delhi level returns, my Lord. So they are working on daily wage basis. Daily wage basis.
Employees.
Yes, my Lord. In the establishment for last, all of them have been working for more than 20 years, my Lord.
More than 20 years.
Yes, my Lord. That is admitted fact, my Lord. And they approached this honorable court in different years, my Lord. And this petitioner has approached in 2015 with a prayer to regularize his service on the ground that he has been working in the establishment for more than, at that point, it must be more than 15 years. And
This Honorable Court, my lord, while issuing a writ of mandamus, my lord, has directed the authority to create and sanction the post to regularize the service of the petitioners.
Yes.
And this particular, my lord, apart from this writ appeal, all those connected writ appeals, there are all total 70% of DLRs.
20%?
70 daily laborers. All of them have approached this Honorable Court and got similar orders. So all those orders have been challenged before Lordship in different rate appeals.
Yes.
But the order is same.
Yes.
Now,
Common order.
Common order.
Common order.
Not common order.
Identical orders.
Identical orders.
Okay.
So Lordship,
That is the first ground
yes,
of appeal.
Lord, my first ground is, Lord,
Yes.
that while the High Court, my lord, exercising, my lord, discretionary jurisdiction under Article 226, my lord, cannot direct for creation and sanction of posts.
Suppose if you continue the persons in employment for more than a quarter century,
Lordship.
still their
Yes.
tenure should not be assured.
Yes, my humble submission is yes, my lord. It is purely within the domain of the.
Once the first contention of the appellant is that a writ court cannot direct creation of posts
And
for
sanctions.
accommodating the daily wage. The creation of post will involve financial implications, and therefore sanction of finance department is a must. First point.
Yes.
Next point.
Next point.
Any judgment in support of this?
Yes.
Give that.
Lord,
In support of this, he presses into service a decision of the apex court in.
Lord, may I just one. Lord, before the
Senior, kindly sit down.
Sit down, sit down. We will hear you. We will not pass any order without hearing you.
before the honorable single judge, my lord, I have filed this written memo of citations, compiling all. My lord,
You tell the citation.
Yes.
Thereafter, you will look into all that.
State of Rajasthan versus Doyalal, my lord.
Wow. We can give it to
My lord, I would, my lord.
Citation, you will give that one.
Yes, my lord, because I have brought 2 copies of these compilations
Okay.
for your lordship's convenience. It was also filed before the honorable single bench. Now I have cited the case of Uma Devi, my lord, and
regarding sanction and creation, you are citing state of Rajasthan, but Dalal versus Rajasthan.
Ilmo Devi, my lord. Your lordship will.
2011, 2 SEC 429, which is the paragraph. Otherwise, to read all this, I have to take 6 months sabbatical.
Lordship.
Ilmo Devi, you are saying Ilmo
Yes,
Devi.
Ilmo Devi.
That is 2021 SEC online.
Yes.
SC 899, page 290. What the
Give paragraph also.
Yes.
Apex court said in one matter, judges should not entertain the dumping of judgments in the.
No, this is the.
I should say for judgments, facts of the case, relevant paragraph. With that, you have to give. Otherwise, you have to write the thesis. Yes. First point is over now.
Yes.
Go to the. Which is that 1 second. Just show us the paragraph.
Yes, para 24, 25, 26, 27, 28 of Ilmo Devi.
Your running page number?
290.
27 is. You're saying 27, no? It starts at 27.
Lordship.
Paragraph is
24 onwards.
24 onwards. 294. You're saying 24 to 31.
Yes, ma'am.
Or 29.
Lord, I'm just reading 25, Lord. That question has been answered here. May I read? Page 25, page 296, para 25. 296 page.
You are right.
Para 25.
Observations made.
are on in paragraph 9 are on surmises and conjectures. Even the observations made that they have worked continuously and for the whole day are also without any basis and for which there is no supporting evidence. In any case, the fact remains that the respondents served as part-time employees and were contingent paid staff. As observed above, there are no sanctioned posts in the post office.
But whether these people are part-time employees?
No, they're
full-time.
Full-time.
Okay.
But thereafter, next two lines. The High Court, it starts from the High Court. The High Court cannot, in exercise of the power under Article 226, issue a mandamus to direct the department to sanction and create the post. The High Court, in exercise of the powers under Article 226 of the Constitution, also cannot direct the government and or the department to formulate a particular regularization policy. Framing of any scheme is no function of the court and is the sole prerogative of the government. Even the creation and or sanction of the post is also the sole prerogative of the government, and the High Court, in exercise of the power under Article 226 of the Constitution, cannot issue mandamus and or direct.
25-26 we are right now.
Lots of talk.
One thing. There, it was a matter relating to part-timers. And they did not do for more than 20 years.
Yes.
Two factors militate against you.
Of course. Then to address the, as you lots of said, that they have been continuously working for 20 years.
But even according to you, more than 20 years.
Yes, my lord. I also do that. Now, the next judgment I will show, where the Supreme Court says, my lord.
No, one judgment is something.
They say the period of service cannot be a guiding factor to decide the regulation of service.
Any length of service.
Yes.
But that we will loosen into 2021. That the earlier we, the longevity of the service is irrelevant, is loosened in 2021.
Lord, so far as Umadevi case is concerned, the first case is Umadevi, my lord, they have described, the Supreme Court has clarified. In which case, yes, whether they are illegal appointments or irregular appointments. In case of illegal appointments, they cannot be regularized. If they are irregular, subject to having qualification to be appointed in the sanctioned post, then they will be absorbed by the government after working for 10 years.
What is your answer? Are the illegal appointments?
Yes.
How? Who appointed them?
Well, the management has appointed them.
Management. But who is the appointing authority?
The board.
The board has appointed
them. The board has board management.
1 second. Let counsel for the appellant admits that board of management being the appointing authority has made these appointments.
Yes, it is not disputed. But not against the sanctioned posts.
However, these appointments are not against any sanctioned posts.
Yes.
Yeah. Now any selection process happened.
No public advertisement was.
No, it's not. Need not be public advertisement.
But that
some interview, some verification of document, or only you come and join tomorrow. Was it that kind of order?
Lord,
or there was some selection process?
No, as per my insistence, Lord, I have since that was not argued before the honorable single bench. Lord.
No, we are asking you.
But what has happened, my lord, at that point of time in late 1980s and 90s, my lord, the then EIC, engineering chief of the board, and some of the senior office bearers, my lord, they have engaged all those persons as the Delhi members. So there is no transparent recruitment procedure adopted by the authority.
Can you argue transparency after 25 years?
Then that when the initial
life has gone now.
Lord, legally speaking, my lord, I have a case, but so far as the content, because they are the person who are giving the instructions to appeal people also. As on date, they are the person who have been. Lord,
we are in law. We are asking.
Yes, Lord.
Can we just say what Babur came to India in 1526, first Mughal. Can we now say the Babur was not justified in using the horse? Can we go to that extent?
No, not.
Somewhere we have to cut the line. Is it not? Having taken their services for quarter century, can you now turn around and say these are illegal appointments?
About
illegality, year by year, diminishes. And at least by quarter century, it withers away.
Yes.
It's a diminishing factor. Suppose if you had to do, and what action you have taken against the management for making illegal appointment?
What?
But then
The fact
Cabinet Council, when specifically asked as to what action is taken for making illegal appointment, concedes that no such action is contemplated, not taken. Not taken, not contemplated.
now, my lord, it is in PSU, my lord. Now, it is the Odisha Water Supply Storage Board, my lord, it is created by virtue of the Act of 1991, which is Odisha Water Supply Storage Board Act of 1991.
It's a statutory corporation.
Yes. Now, under Section 9, I have also enclosed a copy of that. If you lordship will page 35, my lord.
This is for the argument, for the contention. What contention you are? What is this?
The job, the service condition, and the nature of engagement. Or
when that act is
1991.
91 Act.
Yes.
These people were appointed when?
Thereafter.
Subsequently.
Yes.
91 Act, which section?
Section 9.
Section 9.
Yes, Bruce.
What does it say?
Page 35, no? The board may appoint such officers and employees as it considers necessary for the efficient performance of its duties and discharge of its functions against posts sanctioned by the state government. So therefore, my lord.
Did you send any proposal to the government for sanctioning?
Yes, my lord.
When did you send? What happened to that? Show that.
That was not filed.
Yeah, that Section 9 contemplates a process that the corporation cannot work without men.
But the appointments must.
No, we are asking you. We want to learn from you. Can the corporation, this is what someone says, corporation is a legal entity. It has no blood, bone and flesh, and therefore it has to depend upon men. You depended upon these men.
Not.
Is it not? If there were when did you send a proposal to the government for sanctioning of the posts?
But that what's it on?
Yeah. After the judgment, you are saying. We want
in my case, my lord, they have sent on 36/19.
30 June 19th?
1998.
98. But before that, these people had gained entry to the service.
No, her case is different.
No, my lord. Thereafter, your lordship, sorry.
Yes.
My lord, in WPC number 12794 of 2015, there is an order to that effect on 21/12/2021. If your lordship will permit me, I can read.
To the effect that?
To the effect of very clear, my lord, order.
What is that?
Because they have sent to government that 92 posts are vacant. Please regularize it.
Yes.
Your lordship is very clear.
Yes, but your case is then different. His argument is Section 9 of that Act that they can appoint against posts sanctioned by the government.
Correct.
So when the appointments were made, there were no sanctions.
No, there are sanction posts.
So
It is.
basically, you may have a much better case.
But his contention is this.
You may have or Mr. Senior may have a case because you are saying that you were appointed when 92 posts were vacant.
But no, my lord. They had
or are available.
no, I was appointed in 1993, 94, 95.
Not that the date of appointment.
But
They have written a letter that allow us to give appointment. 92 posts are there. That you are saying.
No.
You have read that correctly.
No,
They were appointed.
That's what.
Language is keeping in view of the above ongoing projects and the proposed projects to be executed by the OWSSB in the coming days, the strength of the present staff position is too less than the requirement. It is submitted here that services of 15 numbers of ministerial staff and 10 numbers of technical staff have been regularized during 94-96 in 2 phases. Further, as per the decision of the government, service of one of DLR staff engaged prior to 12/4/93 has been regularized. The rest 92 numbers of DLR staff engaged after 12/4/1993 have not been regularized and continuing as such on DLR basis. By this time, the said 92 numbers of DLR staff have rendered more than 15 to 20 years of service under OWSSB. At present, they are getting daily wages as per L&E guideline. It may be submitted here that the need of manpower under ministerial cadre to assist in the monitoring of the ongoing projects as well as the projects to be implemented in future are essentially required in the interest of the work of the state government. Moreover, considering the growing demand, proposal for creation of regular posts under different cadre has been submitted to the government in H&D department by this office letter number 122 of 10/1/2006, 195 dated 19/1/2006, 95 dated 19/3/2007, then again on 22/2011 and 28/2011, 16/3/2011.
Any number of dates. Okay, next one.
Letter has been given. Therefore, so far as grievance of the OWSSB Workers Union of Absorption under work charges establishment is concerned, the additional financial implication will be around 84.55 lakhs per annum, which may be met out of A&S charges being funded through state budget. The detailed statement of financial implication is enclosed at Annex A. It is therefore requested that the government in HUD department may kindly consider to regularize of services of 92 numbers of DLR staffs OWSSB under work charge establishment as may be adopted for the PH and organization in the interest of public services.
And you have done this letter.
Yes, but the state has denied it.
Very welcome. Learned counsel appearing for the appellant submits that his client had sent a proposal to the government wide letter so and so where
2006 to 2011
during the period between 2006 to 2011 seeking creation and sanctioning of the force, specifically stating that the workforce now in employ is required for the accomplishment of government projects and that more workforce is required than the existing. First, it also said that several persons already employed, engaged in the services of the appellant have been regularized in a phased manner, and therefore these persons also may be regularized on par with work charged establishment staff. Which is that document? Sir, which document you refer to? Yes. Is it part of the record in?
Yes, part of the record. Yes, part of the record.
Annex. Refer to in the bracket. Refer to annexure. Annexure 9. WPC. Annexure 9 in WPC.
255. No. 12794 of 2015.
12794 of 2015. Name of the case? Between?
Vijay Kumar Samal versus State of Odisha.
First case.
This first case.
This first, in the first case itself.
Yes, ma'am.
12794. What is the annexure number, sir?
Annexure 9.
Annexure 9. Okay.
In my case, since 98, they have sent the proposal.
72 to read petition. Annexure 9 of WP. 12794 in 2003.
In my case, they have sent the proposal since 1998 for creation of the post.
1998 itself.
Yes. I will provide the document to the report. Board resolution is there.
Is it true? What Madam is saying is true.
Yes.
Yes.
True.
No, it is part of record.
No, just we are asking.
Yes, sir.
Mr. The panel counsel appearing for the appellant concedes that even in 1999, 98 or
36, 1998.
Even on 36, 1998, a proposal was sent by the appellant to the government seeking a creation of courts.
But subsequently, state government refused to.
Which date it refused?
No. After I filed the writ application, there was an order passed by this honorable court that since you have passed a resolution on 36, 1998, and the state government is not taking any steps, therefore the time-bound direction was issued to pass an order. And
consider that representation.
No, consider that resolution of the corporation.
That was in which WP it was?
Yes, that was rejected.
One second. Since no decision was taken on the said resolution, some employees had filed. One employee had filed WP number.
That is WP number 20774 of 17.
Slowly, he has to take down. Even I cannot take down.
20774 of 2017.
17.
And by the order dated.
Disposed of on.
No, disposed on. That is an interim order.
That's an interim order?
Yes.
Fine. Seeking, what was the prayer in the writ petition?
Regularization. Regularization.
Seeking regularization. First. A learned single judge of this court wide interim order dated
6/2/2020.
6/2/2020. 20.
I directed to the state government to take a decision on the resolution.
Directed the state government to take a call on the subject resolution. And it rejected when?
It was rejected on 8/8/2022.
The government rejected the proposal on
8/8/2022.
2022.
Well, in my case also, there is a resolution, there is a board resolution wherein that they admit that I'm just reading one sentence, my lord. That is also 30th June. Sorry, my lord.
Date of the resolution.
30th June 1998.
Same resolution.
Which matter? They state about the vacant position. I'm just sitting here. The post suggested annexure 4 was dropped, and it was considered to create 10 numbers of additional posts in class 3 cadre to accommodate DLR proposal to be maybe moved to government in H&D department for approval of the same. It was also reserved to fill up the vacant 44 posts from existing DLS through recruitment committee of the board after observing merits in native provision. So there are 44 posts were there to accommodate the another.
Sorry, sir, may I suggest one thing?
Sorry.
Your answer to his citing section 9 is that there are already vacant posts and board was empowered to appoint itself. So you have to cite that. Your response to his citing section 9 would be that since board is empowered to create posts and made appointments.
Made appointment.
By resolution.
Yes.
So that specifically you have to give those details also.
No, but these posts
counter the submission that only sanctioned posts can be filled up by the statutory corporation.
There is a clear vacant post.
I'll have to section 9, my lord.
I think you will concede that.
He will not concede because
Clear case
he
of
reads
vacant
section 9. What he says is
that vacant posts are already sanctioned because he has to consider the vacant posts are already to be sanctioned.
But they were not engaged against any sanctioned posts, so therefore they cannot
sanctioned posts.
If there were sanctioned posts, you do not appoint them in sanctioned posts but give them daily labor rated, then what would be the answer? Yes. But so I suppose there are 100 posts, sanctioned posts, but you do not appoint 100 or say appoint 50. Rest 50 you give PLR. Then 9 will not come to your rescue.
When the posts were sanctioned?
Sanctioned and
when were the posts sanctioned? Because section 9 reads, board has got power to make appointment to the posts to be sanctioned, created and sanctioned by the government. That's what you read the other
9-1.
Simply says against posts sanctioned by the government.
Yeah.
So if it is there, it is there.
Prior sanctioned post.
Prior Yes, it is understood prior. But suppose there are posts. What they are saying that Section 9 doesn't come to your help because there are sanctioned posts.
No, there are not posts.
There are posts. Which are sanctioned.
Where is that?
So that is not his case.
That is what I'm asking.
That is not his case. Then he has to argue that.
So you are banking upon Section 9.
Yes.
And you say that your creation of post is by whom?
Not by the state government.
Where is that?
The sanction post in the year 1992.
Correct. No, we are just asking.
Because we're still exploring. We have to understand that.
Let us read Section 9 once again. Read Section 9.
The board may appoint such officers.
Give us 1 second. 1 second. The board may appoint such officers and employees as it considers necessary for the efficient performance of its duties and discharge of its functions against the force sanctioned by the state government. Means what? Posts sanctioned by the government means what? Creation of posts and then sanctioning of posts. Both. Or you will create the posts, but sanction will be taken from the government. What is its meaning?
The board is only empowered to
make appointment
against those posts which have been sanctioned by the state government.
But the state has not sanctioned even one post.
No, state has sanctioned.
Sanctioned how many posts? When?
But initially, when the board was not.
So thus, can you read complete reading 9 complete? 9, 1, 2, 3, 4.
No. 9, 1.
Other question.
9, 2 is salary, recruitment and the conditions of service of the officers. No. The salary, recruitment and the conditions of service of the officers and servants of the board shall be such as may be determined by regulations by the board. 3. The board may, with the previous approval of the state government, appoint a servant of the central government or the state government.
May not be necessary. That is not your case.
Subject to the superintendence of the board. The member secretary shall be the chief executive officer of the board and shall supervise and control all its officers and employees, including any officers of government appointed or dictation to the board.
And this is the only provision.
Any regulations are promulgated?
No. No regulations and no recruitment procedure also.
Says office.
No rules. No rules.
Regulations and servants of the board and their enforcement and conditions of service.
In your state, the marginal notes are also passed in the legislature, or they are not voted.
It's passed by subject to.
Well, in the Amarkant case and Nehal Singh case, the Honorable Supreme Court has specifically these type of cases are categorically stated that since you have been engaging them for years together, there is necessity of continuing their services and posts are to be created. Specific directions are there.
Will come. Yes. Your second point is you are answering how many posts were sanctioned by the government and when?
Not as on, I have the statistics as on date how many posts are vacant. That I can.
Yeah.
As per the board resolution, my lord, 44 posts were lying vacant at that point of time.
Where they sanctioned?
44% sanctioned posts were there and 10 posts of grade C posts were there.
View that.
They are recommended for regularization.
There are total 63 sanctioned posts, out of which 32 posts are vacant.
63 posts.
63.
These posts relate to which category? No, you have not appointed them against the sanction post. We have argued that now.
grade C and grade D.
Class 3, class 4.
Class 3 and class 4 employees.
No, in this, where they fit into.
Lord, in this they will fit in junior clerk, junior typist, clerical work, Lord, being done by 10 to 15 persons, and rest, Lord, class 4 employees.
Class 4 means your night watchman position, because light vehicle driver is 3. Direct is also again 3. High Court expressman direct is 2. Now, so this year, some people, juniors, senior clerk, junior clerk,
is not in order. It's not in order. So, how many posts are vacant as on today? All posts are vacant because you have not made appointment.
32, sir.
Last horizontal lines.
Out of 63 sanctioned posts, 32 are vacant.
32 are there. Of them, how many of them can be regularized in those posts?
32 of them can be regularized.
But totally, how many are there?
There are more than 70, my lord.
More than 70. For these 32.
32 means you have to.
32, I'm sorry, yes. But they did also include the
It will not be 32 because higher rank people are there.
I am an engineer. My
You are
post is engineer.
So madam's case is slightly different. So I'm only talking about the DLRs.
DLR. We will argue madam's matter separately. So, you will leave madam to go home today.
No.
Yes.
Well then, was 617. So.
No, you said it is not 32.
16 to 20 maximum.
So here, you only 25. As you look at it, your night watchman only 5. Okay, driver maybe. There are some drivers.
Any drivers?
4 drivers can say.
I've got a gradation list where in this.
Five peons, 4 drivers.
Then junior clerk, senior clerk, 7.
Seniors. Totally.
And then stenographers are there, then 5.
Any stenographers are there?
No,
No stenographers. Then stenographers are not there. Number 1, not possible.
Respondents, please have to work out actually. When you are seeking this response from you, be particular because mistakes will also be the problem.
No stenographers. So, junior stenographers. Senior executive assistant? No. Perhaps madam's client may come. Let us see.
No, one stenographer is there. Abhitar 37.
One stenographer is there?
Yes.
It's on 7 in my case.
Then junior stenographer. Thank you. Yes.
1.
Only one response. One junior is 1, 8 and 1.
Clerks.
Clerks are there. Clerks are there. Clerks are there, prisoners. At least in my case.
They are in the scale of junior clerk or there is a problem also?
No, they are doing.
After that Supreme Court direction for equal pay for equal work, they may be getting higher pay now. So if you compel them that you enter at the entry level, it will not be beneficial.
That DLR there.
They were working DLR for the clerical works, not specifically. Clerical work they are doing.
So 6 plus 1, 7 at the most.
Since 93, 94, 95 like this.
How many clerks are there?
Well, to find out.
The data is necessary. How many clerks are there? How many are qualified and how many are seniors?
Qualified they are, my lord, because my case wherever they are here, they are qualified. They are all +3 commerce graduates, science graduates like this. So clerical, you'll have to calculate it, my lord. In my case, I'll have to calculate it what the clerical, doing clerical job, what doing PN job.
What is their present status, though, even though they are engaged?
So they're doing same work till now.
Salary. Whether they are
salary means they're getting daily wage, a monthly concentrated salary. Monthly concentrated wages.
So what happened after that Supreme Court decision that they are being paid the minimum salary at the entry level? Actually, they have also been given maybe some increment.
They are getting the salary of skilled labor.
Skilled labor. All are skilled laborers.
All are given skilled laborers salary.
Yes, Lord.
You check it again.
Lord, I'll check.
There is a gradation list. The gradation list was published. In the gradation list, 87% were there. There are peon, clericals, and other scholars. Then total 87%. That is, I have added a document.
I have also added.
We are now considering. Yes. Section 9 is whether applicable or not, it's one of. But in the available vacant posts, which are at the state, how many can be
accommodated? Questions.
Basing upon
the things we can argue the matter.
They are basing upon the seniority matters.
Correct.
Basing upon the seniority, the gradation list was prepared. And
the respondents have to agree that the first come will get the fast.
Let them take a decision.
Part-time bill submitted by there is no illegality in the judgment of the honorable single judge by directing for a creation of the post because.
But Apex Court says you cannot create.
No matter that Lord Sima kindly Niyal Singh case and exactly in simple. But Apex Court judgment, my learned friend is stating that is in case of part-time workers. But in our case, Lord Sima kindly Niyal Singh case and the case. The clear direction of and especially this category of persons.
We'll come back to you. But we don't want to disturb him more.
No.
We have already disturbed him enough. Yes. Your first point is over. Second point is section 9 you quoted.
Yes.
Your first one is post cannot be created without sanction of the government. Therefore, the
judicial review
they cannot be accommodated.
Judicial review is not permissible so far as
creation and sanctioning of the post is concerned. Number 2 is section 9.
Section 9. Since none of the respondents were engaged against any sanctioned post, so therefore they cannot be now they are stopped from claiming that I should be accommodated against a sanctioned post because these are all public posts. And the law is also well settled that whenever any vacancy arises, so far as any public post is concerned, then the requirements to fill up that post is to issue a public advertisement.
But you did not do that.
Because they were daily wagers.
How long?
For them, they were not engaged against any public post. So that
what do you mean the way?
What my lord is telling you, that it was at your instance.
You appointed them.
Lord,
So when you do something and you cannot attribute that to them.
But may I just give an illustration? What the performance, what the function of the Swaraj board is? Now it carries out the Swaraj works throughout the state of Odisha.
So that one, you do something, extract the work.
Temporary.
Then regarding the appointment, you see, suppose you say that there were two kinds of appointments. One was by advertisement, one was by this method.
Yes.
But this is the only method you have now adopted. So that is the next question would be that who did it?
Not out of 60.
Your management did it.
Not survive out. Yes, my management.
So your governing body did it.
No, the member secretary has issued the appointment.
Member secretary he himself offered the appointment. He issued the appointment.
No, the discussion, Mr. Pandey, you were there. Now, he passed that whether you have taken any action. He said.
No, we have not taken any.
Whatever he has answered, he's answered. Very fairly.
Board has not appointed.
Board access has not. The member secretary.
No, they have admitted
Head of the board.
No, there are 70 to 80%. Individually, I cannot say who have been appointed in what manner. Which manner.
Beginning here,
any resolution permitting the member secretary to make appointment?
No.
Did you take up that contention in your objection statement?
Yes, I have taken in my counter, my lord.
What you have taken?
Because in the counter, they have categorically admitted that the board has appointed. I mean, the counter they have categorically admitted.
Yes, in the counter paragraph,
paragraph, my lord, in my case, it is page paragraph 8.
In all cases, individual objections are filed or only one single objection?
No, in all cases, my lord, I have
Separate
Individual.
Yes.
But in all cases, you have admitted that board has appointed.
In my case, my lord, I can read out, my lord, one sentence. The services of the petitioners were taken by the board as a private arrangement, and petitioners are allowed to function in the post of clerk, peon, computer operator, stenographer. This was not sanctioned. No rules had been.
Yes, you have admitted. Board has made the appointment.
Sir, only one thing that when they say board, they refer to the name of this Odisha Water Supplies and Sewerage Board.
Yes, yes.
Not the board of the management.
No, the board of board.
What about Odisha Water Supply and Sewerage?
Because he says he concedes. He says that only secretary appointed.
No, secretary, but the board.
Is there any kind of board resolution or document?
Here they say that it was taken by the board. If they say admit that.
Board means to say Odisha Water Supplies and
Supplies by board, naturally. That is the appointed. That is the authority.
Yeah, but throw light on what was the background of those decisions?
No, that is the board.
Under the act, no?
Under the act, it is the board of chief executive officer is to only issue the appointment letters. There is nothing urgent.
In para 8,
Contention has taken that the board has engaged in the services of these people. And after all, it's a doctrine of indoor management. He cannot ask, employee cannot ask, no, whether show us the board has made resolution, etc. They will be thrown out. It's a doctrine of indoor management. What happens indoor will not be known to him.
Look, I am not, only the question is whether they're entitled to regularization service. I am not disputing their appointment letters or their engagement. Now, whether they can be regularized in their services, that is the question for consideration, Lord. And in Umadevi case, Lord, so far as Delhi laborers are concerned, the Honorable Supreme Court has also, Lord, in paragraph 42, may I just read what the observation made by the Honorable Supreme Court.
If entry level is illegal, then no question of regularization.
And they say that it is irregular, not illegal.
If it is irregular, then regularization is possible.
In the counters also they admitted it is irregular, not illegal. In counter they have admitted that the appointments are irregular.
Where have they stated?
Is this in the counter ballot? In the ballot based counter they have said?
Which paragraph? No,
it is
irregular
appointed to send. Such irregularly appointed persons cannot claim to regularize alleging violation of Article 21.
I was explaining the settled principle law in one paragraph. So that in that
context, no, where have you stated all these appointments are illegal?
Yes.
Show that.
Not in paragraph 2.
So your WPC number is?
WPC number is
and corresponding
34683 of 20 and corresponding number is W number is
877.
877 or 24.
23.
Not
877 that could.
Show one sentence where you have said, yes, these are all illegal appointments. Number one, then substantiate how it is illegal.
Lord, I have taken the course of section 9, as I have written the aforesaid section 9 of the Act makes it abundantly clear that the board may appoint such officers and employees as it is considered necessary for the efficient performance of its duties and discharge of its functions, only against the post sanctioned by the state government. But in the instant case, none of the petitioners have been appointed, engaged by the board against any sanctioned post in terms of section 9 of the Act, as a result of which the engagement of the petitioner are to be considered as illegal appointment. And therefore, the petitioner for regularization of services, the prayer for the regularization of services are not permissible, as has been held in the constitutional bench judgment in the case of Umadevi. Moreover, none of the petitioner...
So that panel counsel.
It is stated only in writ appeal.
In writ petition, you have
counter affidavit. Counter affidavit.
Counter affidavit, where have you taken that?
28th of April 2022.
In affidavit you have taken?
Yes.
Now which you have read it is from the affidavit?
It's counter affidavit. But in WPC number 32358, so not, in all these cases I have filed counter affidavit. Now if my learned team...
Now Sejio's case is 34683.
So the panel counsel appearing for the opponent submits that.
34683.
Though this board has made the appointment, Para 6, being the appointing authority under Section 9 of the Act, such appointment is not against the sanctioned courts. And therefore, the entry level itself is illegal.
Paragraph it cannot be illegal. You can, because in the absence of specific pilot, that is his contention. But the absence of the rules, recruitment rules pilot, the appointment cannot be said to be illegal. Had there been a recruitment rule and they have not followed it, Madhavi case is very clear in that respect.
In support of that, he banks upon
That is another.
Uma Devi, paragraph
42. Referring paragraph 42.
Paragraph 42.
42. Okay, next ground.
Not the another Lord, while the Honorable Single Judge was pleased to allow the writ petition, Lord, he has relied upon an order passed by the Honorable Supreme Court in one of the cases where one of the DLRs, Lord, he filed a writ which was allowed in his favor for regularization of services, and that
is A.K. Panda.
Yes,
A.K. Panda's case.
No, D.K. Panda's case.
Huh?
My case first. In my case.
No. Writ appeal number 10046 of 2008.
No, that writ petition allowed, writ appeal was dismissed, that matter was challenged for the Supreme Court also dismissed. So similarly placed 4 persons were regularized. And not only that, in the other writ applications also, they have been regularized by order of the Honorable Court.
And they are all juniors. And they are all juniors.
And it takes
Will come to proper also. But that posting part.
one case there is direction for consideration.
See, there is one difference. Uma Devi judgment was structured keeping in view hierarchical system operating in the government.
Yes.
That's the point. The government did not make the appointment. Some officers had made appointments. Those officers were not authorized to make appointment. Therefore, that question matters. In your case, you are the appointing authority. You are the government. So therefore, power to appoint is not in dispute. Your made appointment is not in dispute. Whether that appointment is illegal or not is the question.
Yes, of course.
But at this length of time, whether that question can be argued is, we are not that sure. What Nihal Singh said.
Lord, I'll just show one, because I have compiled so many judgments, and all of the judgments say that the tenure of service should not be a guiding factor. Lord, what has happened in Jammu Kashmir High Court, lots of people are working as daily-wage members. The High Court first, Lord, regularized them.
Okay.
All of them considering the tenure of service, Lord. Lord, how the Uma Devi judgment has been interpreted? Because they
several other judgments. M.L. Kesari, Nihal Singh, and many other cases.
And a recent judgment, my lord, in Jago case.
Recently, Jago case. So citation review.
That is, my lords, in paragraph 46, my lords. While the judgment in Uma Devi, Jago versus Union of India, my lords.
Civil appeal number.
Civil appeal number, SLP number 5580 by 2024. 2024. Decided, my lords, on December 20, 2024. 2012, 2024. Yes. Well, paragraph 46, my lords. Well, the judgment in Uma Devi sought to curtail the practice of a backdoor entries and ensure appointment adhered to the constitutional principles. It is regrettable that its principles are often misinterpreted and misapplied to deny legitimate claims of long service employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and are served continuously for more than 10 years should be considered for regularization as a one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claim of the employees, even in case where the appointment are not illegal but merely lack of adherence of procedural formalities. Government departments are often cite the judgment in Uma Devi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment explicit acknowledgement of the case when regulation is appropriate. This selective application distorts the judgment spirit and purpose, effectively weaponizing it against the employee who had rendered indispensable service over decades. In the light of this consideration, in our opinion, it is imperative for the government department to lead by example in providing fair and stable employment, engaging workers on temporary basis for an extended period, especially when their roles are integral to the organization functioning, not only contravention of the international labor standards, but also exposes the organization to legal challenge and undermines the employment morale. By ensuring fair employment practice, government institutions can reduce the burden of unnecessary litigations, promote job security, and uphold the principles of justice and fairness, and they are meant to embody. This approach aligns with international standards and set a positive precedent for the private sectors to follow, thereby contributing the overall betterment for the labor practice of this country. I'm giving that one.
And your lordship will see from the Niyal Singh case also. Sorry.
Ticket is not yes, 169. Just
24 AC online. 24 AC
paragraph 26 and 26.
2024 ACC online. 2826. 3826.
Lord, and that's just my lord. And thereafter, my lord, that is Shripad judgment, my lords. I'm giving a copy. That judgment was said. Yes.
Which paragraph?
Shripad, my lord, that is Jago. That they have followed Jago. They have followed the Jago, my lords.
Yes, brother. Well, what is the next point?
Page 181. My lord, I will only cite this judgment, my lord. Then the court framed two questions, my lord. That the right of employees seeking regularization on the strength of long and continuous work. And the second is the correctness of directions issued by courts for regularization of employees under Article 226 of the Constitution. Lord, I am in this case, Lord, what I was telling you, Lord, that the Honorable Jammu and Kashmir High Court regularized the service of all those jailers who were working in the court for last, Lord, 2 decades.
Yeah.
Now,
longevity of service is irrelevant.
Yes.
That's what you are saying. Penal Council submits that while considering the case for regularization, longevity of service of an employee fades into insignificance if entry levy is polluted by illegality. Correct?
Yes, sir.
Any other point?
And the other ground, the other ground on which the appeal is filed, that the Honorable Single Judge has relied upon the dismissal of the SLP referred by the Swaraj Board, challenging the order passed by the Division Bench of this Honorable Court, which has upheld the order passed by the Honorable Single Judge in directing regularization of service in one of the DLRs. Lord, my humble submission in that respect is, that is a case of, there is under Article 14, there is no such prescription called negative equality, and such dismissal of SLP limine,
Learned Single Judge, lastly, he submits. Learned Single Judge is not right in taking decision of the apex court which are dismissed the SLP in as much as unless leave is granted, the decision does not become a binding precedent under Article 140. These are the grounds. Yes. Now, what are you going to do?
Only to suppose is last question, last argument is concerned, I will only put one sentence. That 141, Article 226 doesn't also 141. What happened, my lord? Negative equality cannot be said in case of judgment of the Honorable Court. Judgment of the Honorable Court is law, judgment is law laid down. So negative equality, the principle negative equality is not applicable in this case.
Mr. Mishra denies this contention.
Then, my lord, considering that Tumadevi, the page 56, I have filed those documents 2015 one about
yes,
Kantra
you
case.
Can go further. We have treated Umadevi a number of times.
Para 2012, their lordships have quoted Niyal Singh, therefore I am referring. Yes. Applying the ratio in the of Umadevi, the case, this court in Niyal Singh versus State of Punjab directed the absorption of special police officers in the services of the State of Punjab, holding as under Niyal Singh Supreme Court case not 35. Therefore, it is clear that existence of a need for creation of the post is a relevant factor with reference to which executive government is required to take rational decision based on relevant consideration. In our opinion, in the facts such as the one obtaining from the instant case demonstrate that there is a need for creation of post. The failure of the executive government to apply its mind and take a decision to create posts or stop extraction of work from persons such as the appellants herein for decades together itself would be arbitrary inaction on the part of the state. The other factor of the state is required to keep in mind while creating or abolishing the post is the financial implication. In not financial implication, but I'll show to you how in this case financial implication is not there. Para 13 of this judgment that Amarkant Rai. In our view, the exception carved out in para 53 of the Umadevi is applicable to the facts of the present case. There is no material placed on record by the respondent that appellant has been lacking any qualification or bore any blemish record during his employment for over 2 decades. It is pertinent to note that services similarly situated persons on daily wage for regularization, that is one so and so, was appointed on daily wage basis on the post of clerk regularly effect from 1987. The appellant, although initially working...
You are reading from which part?
It is Amarkanti judgment, 2015 on the SEC. 2015
directly you can go to Nihal Singh, na?
Because Nihal Singh judgment has reiterated here. That is the reason why I am referring this.
Article 141 says, law declared by the Supreme Court binds everybody. It does not say, law repeatedly declared by the Supreme Court binds. That's not the one judgment.
One judgment.
Though one swallow makes not the summer.
Yes, my lord.
But one judgment makes the.
Then I'm taking lordship the Nihal Singh judgment, my lord.
Yes.
Nihal Singh judgment, my lord. It is there.
Anyway, we know that. Speak to what?
overemployment, that has not been your standard.
It has not been done. It has not been done. Nature is perennial in nature. Work is perennial in nature.
That he opened as a statement. He has been that way.
He has not. Neither he has stated that we are not qualified, nor he has stated that it is overly given. Rather, it is contrary to the own document which was cited by mail on print, that they have recommended for regularization again and again.
Waiting for the respondent employee submit that. In the specific case of the appellate, that the board had made the appointment. All these employees are not found to be deficient, either in the qualification or discharge of their functions. The board itself has specifically stated to the government that the services of these people is eminently required or eminently required, and therefore had sought for sanction from the but they also think government case wherein the learned fingerprint of this court has directed regularization of services of one of the employees. The matter was taken into appeal and thereafter to the apex court where it learned fingerprint order came to be in effect. In fact, the appellates themselves in their resolutions had mentioned about 3 sets of regularizations to be precise, while recommending to the government for the regularization of these people. First now, the council for the respondent rely upon Shripad, Kesari, and Jacob.
I mean, Kesari, Amarkant, all these judgments. All these judgments.
And I am citing one judgment, that is Madras High Court judgment. I am just not reading, that is paragraph 19 to paragraph 32.
Madras High Court will not bind us. We are far away from Madras. Third result.
Only one can think.
In my case, you
no, only one sentence.
No, yours is separate. Your case will be treated separately because you said your client is more qualified.
He was not also Delhi wager. He was appointed in a consolidated pay.
Consolidated.
Yes.
Okay. Then we'll have it separately, or we want us to pass a common order.
If your lordship will die,
they are getting the benefit, you are bound to get the benefit. If they are losing, you will also lose. Or you may have some point. Let us see. You have to choose whether you want to get into Titanic or not. You do not know. Only metaphorically we say.
Titanic sank, your lordship, so may not. My lord, 843. I have got a writ appeal. I am the respondent. 843.
Started selling.
The covered, but the
started selling now. So future.
We do not.
To court shot, my lord, my humble submission is that appointment cannot be lead to illegal in the absence of any specific recruitment rule. So appointment is made to be treated as illegal if it complies with the recruitment rule. There is no recruitment rule.
Mr. Mishra submits that in the absence of promulgating recruitment rules for regulations in terms of Section 9, the contention of the appellants that appointment is contrary to the rule has no force.
And financial part, since they are not, he is not argued the financial part also have filed document to the effect that for regular employment they are every 1 crore only for the temporary
85 lakhs. 85 lakhs.
85 lakhs and it is a perennial, the work is a perennial nature because as per the act itself, act provision perennial nature, that is the reason why from 92, 93 onwards they have been working continuously. Against this, that means more than 30 years they have been working continuously.
The grounds taken in the counter affidavit have been dealt with while passing the law. That may be.
All right, we'll consider.
Item number 20, my lord directed me to file a joint memo.
Which is in this matter.
Item number 20, my lord.
Wait, they are all on the speed. Wait, come on.
My judgments are there in the single judge record, along with repeats and along with I have already cited. Memo citation already there, my lord, it is on record
In
the writ petition.
in writ appeal 840. In writ appeal 840.
We'll consider your matter also along with this one.
Yes.
In
Madam's matters also, right? All matters.
In writ appeal 843, your lordship.
Whichever are there, we will treat them together.
The length of service is on your lord.
Yes, yes. Yeah, we have to, that content is taken up, specifically taken up. He was very articulate than all of you.
Oh,
The
yes.
panel counsel was more articulate.
Yes, yes.
Seniority may be considered saying in
And
support.
he was fair enough also.
It supports its
And Mr. Das is fair enough also.
But consider that
Fair enough also is sufficient.
396 years.
Really.
Yes, yes.
But he says, depending upon that Jammu Kashmir matter,
Jammu Kashmir.
that pales into insignificance. Irrelevant. That's your case.
Yes.
Understood.
But member secretary, the counter affidavit says, as and when jobs are required, vacancy, therefore the requirement of the job, we have engaged them.
They have said in three resolutions, they have said.
Yes, yes, yes. That your lordship is.
In W877, all the documents are there. In W877, all the record documents are there with them.
Are available in appeal number
877 or 24.
877, not
I mean, the connected writ petition. Okay.
just that.
34683 of 2020.
Correct.
34683 of
320.
Seniority may be considered.
Thanks.
It is there in the judgment.
Thank you.
Much obliged, madam.
Grateful.
Next, family matter.
But the referral matter will also refer to matters or will we refer?
In all referral matters, we'll refer them
Yes,
to the mediation.
By fixing a date, my lord, so that
In all matters, we have to fix the date.
Item number 49, my lord.
1 second. One matter is being compromised. The parties are here.
my matter is item 47, my lord. Any date may fix or?
No, clearly.
I'm for the respondent. We also want that our matter may be placed before the mediation center.
Are they listed today?
Yes, yes. Well, item 40, item 40.
Mediation. My parties to their concern or to the release of the regulator on the next day.
My lord,
Third week of August. Third week of August.
please go.
19th August. 19th of August 2025. So that's yes. And you'll see the
Item number 40. My lord, item 47 also 47. Item 47 also, your lordship. Item 47, my lord.
mediation.
Mediation.
My lord, item.
Not present by the following.
Research matter is not in that case.
Item number 44. The matter has been posted today for hearing. May I please the lordship sign it?
Item 37. I'm here. Memo has been filed. Item 37. Memo has been filed. Item 420.
20, man. Item 20.
Yes, ma'am. In view of this settlement,
building or
matter can be disposed of. Matter can be
liberty for to the appellant
To revive it in the event they do not comply.
Grateful,
They
man.
will have an order of arrest and detention.
Grateful.
They are not violated, they are violated.
That will suffice, man. Grateful.
The sides have unequally settled the matter on the advice of the advocates. I have filed a joint dated 2025, which reads as a we have interacted with the parties that feel the part. Like the values of the advantage of the first, the settlement, in our opinion, is in the best interest of the parties. There is no reason to doubt the bona fide commission. Next one, the above circumstances, this arranged having been disposed of.
What is the urgency, sir?
34.
34, you take a date from the, no matter will go out of risk. You redistribute, but take a date from
Item 53, we both are there, let it be referred to mediation.
53.
53, the mediation order.
Format you should have that.
Item 53 list kariben.
Item 41. Item 41 which is mentioned to take up as the last item, Mr. M.S.Sahoo Supreme Court advised.
What can be done now? Tomorrow. It is admission matter.
It is admitted and issue.
No, what is that matter about?
Regarding admission of the student.
Tomorrow.
Physically handicapped.
Physically.
Tomorrow.
Fresh admission.
Tomorrow we'll take that.
Lordship, item number 42, Your Lordship.
42. What is the
urgency is the matter would become infectious as there is a
it will go automatically up, but you are not
as the choice locking system will commence in the 1st of August, Your Lordship. And these colleges which has approached Your Lordship DMT authorities have rejected the NOC, Your Lordship. So if at all this cannot be decided before 31st, then Your Lordship.
42 items.
42, Your Lordship.
Monday we can have that.
Tomorrow, Your Lordship. Tomorrow the actual cases are coming.
Tomorrow. It may be taken on Monday, my lord.
both and more. 42 and
students are in.
and physically handicapped.
Yeah.
Mr. Jain has mentioned.
Yes.
41 and 42.
Your Lordship.
Any other admission matter?
I want to withdraw.
Mr. Swine.
42 you want to
So we are taking up 42 tomorrow.
It has been compliant with us.
Which one, sir?
42 he wants to withdraw.
No, Your Lordship. Your Lordship, there are batch of cases. Your Lordship. Batch of cases.
Okay.
So one of the Kalinga is.
So tomorrow you mention, keep that name.
Of them.
Which one?
Which one?
Kalinga Institute.
Kalinga is 19073.
19073.
Mr. Swai, you are there?
Yes, ma'am.
He wants to withdraw.
Yes, yes.
Compliant.
Your name, sir, Maharana? Your name?
Shivam Mishra. I'm on behalf of Sohan Mishra.
Yes, Mr. Your name is
Yes,
also
yes.
there. Mr. Shivam Mishra for the petitioner. Mr. Who is there? Mr. G. Item 42, last one. Mr. Dobras Mahanti, AGA for the state. Mr. Swine on behalf of RC Mahanti for the DMT. They submitted that the petitioner doesn't want to press the writ petition in view of the NOC having been granted by the authority. Memo of date is filed by the Lord and Counsel for the petitioner is taken on record. The writ petition stands disposed on his floor.
File a memo also. You have filed a memo already? Okay.